So it begs the question, why in the world would someone need a personal protection order based upon alleged stalking when...
Right away, this case feels more emotional than legal. But here's the reality. Courts don't issue protection orders for hurt feelings or arguments. They require clear evidence of stalking or credible threats.
Done nothing against this person except for tell her to shut her mouth. My mental health and how I am a psycho bitch. Wife reporting for booty. It has been an ongoing situation that the respondent has been using slurs against my disability. She has been screaming and cursing for children playing in a commons area upstairs in our own level apartment. She has come out and produced a cell phone and recorded myself and my children while she has blocked off the entrance and the stairwell that is the only entrance and exit in the building, while she proceeded to insult me and use discriminating comments. And then she then proceeded to return to her home when I made a police report that same day. It is in the massive stack of evidence. She continues to post on her social media in regards to myself, my mental health, my disability, my whereabouts, my ins, my outs. When I'm doing something, even carrying my child up the stairs, saying I'm not disabled enough to be, unfortunately going to the police department and telling them words that did not get said and using an image that she had requested over a year ago or 6 months ago in lieu of it being where I was at the bus stop waiting for my children, and I had seen the Seaboing chief's wife. She had then made derogatory remarks against me towards the chief's wife, which then caused a stir with me and the chief of police. It caused an emotional distress, causing...
So she allegedly made statements about the chief's wife that made a problem with you?
She said it was me. She said I said something in the matters of his wife reporting for booty duty at somebody's house. And that was not said. And it was a vague picture to show where the house was, because she said, which house is it? And I sent a vague picture. And this was over 6 months ago. And the chief then responded in upset, and that is understandable, but it caused me grave emotional distress, which caused anxiety, hyperventilation, to the point of being extremely ill, to the point of almost blacking out and needing emergency service from my caretaker. And I was on bed rest for the rest of the day.
So what this is about, now mind you, I don't know if this is hearsay or not. I have no idea, but I need to have firsthand observations by you to indicate. But your original request was from, you even mentioned over 6 months ago, correct?
No, Your Honor. This is really confusing, and I had hoped that we had gone last, because it's a lot, and I know you like short and sweet, but
No, that's not true.
There's no short
Excuse
to
me,
this.
Miss, short and sweet? Oh no. If you wanted to see short and sweet, you should have seen my predecessor, whom I highly respect. My predecessor, the Honorable M. Richard Knobloch, it would be more than quick. I allow, and I'm not saying he never did, but I allow the parties the opportunity to speak. And I even asked them again, is there anything else? I do that for a reason, because you are entitled to have a hearing and to bring all this information out. But I take umbrage with that statement that the court looked short and sweet. That's not how we work.
Well, in correlation to what she has never brought to me personally without screaming and cursing at my children first.
Are you alleging it's slanderous?
I am.
There are other causes of action which I can't get into, but how does that apply toward a personal protection order regarding stalking?
Your Honor, she has mentioned, and it is, I am quoting her own personal Facebook page. She makes a comment that she simply said, someone who claims to have PTSD sure causes a lot of stress and everyone in the building if she would stay out of the hallway and stop yelling at everyone or allowing her children to play board games in the hallway, there would be less noise and there would be no complaints, as it is listed in our lease that a commons area is not a playground. If she claims to have such a disability, she can sure climb stairs, stand in the hallway making up her own stories, and speaking Spanish off of the top of her railing to us. I watched her carry groceries up the stairs. I watched her carry a baby up the stairs. She claims that she's been in bed. She claims that her doctor told her my stress is causing her complications. There is no need for someone to be watching the ins and outs of anybody who is coming into the building, especially when making derogatory statements about someone's disability, to tell me or tell her whole Facebook that she is watching me go up my stairs, go down my stairs, every day. And she claims that she is making monetization, more money on the drama here. And this is my personal life. This is my disability. She has no right to say, I am not disabled enough for her own, and then post it on Facebook, having people weaponize themselves and claim to say they can come to my town of Seaboing and open a can of whoop ass against me. I have done nothing against this person except for tell her to shut her mouth, stop screaming, stop cursing, come up and talk to the parents. There was no Spanish. I don't speak Spanish. She is making false claims against me. She even has people of Seaboing that have businesses comment about my mental health and how I am a psycho bitch, that she deserves a peaceful environment. Yet, so do I. I deserve to have a space knowing that I lived there for 4 years. She still moved in. She claims that I have been intimidating her, and then she claims against that, saying that she's been ignoring me.
I'm here today because Brittany is my neighbor, and we used to have a friendship. Our friendship ended in June of last year. I have made no physical contact with her.
And now we see the core issue, a broken friendship turned toxic. The problem? Personal conflict alone doesn't meet the legal standard for stalking. The judge is looking for repeated, targeted behavior that creates real fear, not just ongoing disputes.
Besides a brief verbal altercation in the hallway about her kids being loud, I've lived in this apartment complex for over 6 months. I've never interacted with her. I went on with my life since June of last year. I've gotten pictures put on my door of me coming into my apartment with her own contents. I made police reports. I
Who did you make
also,
police reports with?
the village police
Village of
department,
Seaboing? Okay.
yes. And I've only made one police report in the last 6 months since our friendship has ended. There's only one police report, and that's since I've lived, and that's when it started in March. I believe it might have been end of February, beginning of March. We stopped being friends because Brittany was complaining about other neighbors. I have a lot of personal messages between me and her about those neighbors. And I also have messages of pictures of those neighbors that she took in public places. I also have messages about saying she's going to kick the neighbor's teeth in. I also have messages from Brittany, also with threats of
Y'all can be
saying
seated.
that my
So-
boyfriend flashed a firearm concerns.
705 as well as MCL 600.2950(7). Also, if the petitioner is requesting a non-domestic stalking personal protection order, the court has again state the reasons why, either granting or denying. And that's what the court is doing here. The initial petition was requested ex parte. The court denied that based upon the information that was contained within the petition being insufficient. In this case, we have a relationship, a friendship apparently that broke off either in May or June of 2025. And essentially the relationship went off the rails, according to the petitioner. It was constant harassment, posting of messages, etc., on Facebook, contact in the hallway, etc. All these activities allegedly going on. Further, the petitioner is claiming that messages have been posted since then. The respondent, on the other hand, states in part that the petition, strike that, not the petition, but the friendship broke off again in May or June of 2025. And since then, there have been ongoing issues in the apartment complex, potentially loud noises, children playing in the hallway, whatever the situation may be. But she states under oath as well, as a petitioner with completely opposite evidence, testimony, that she's not posting anything. I inquired of the petitioner regarding whether names were specifically posted of individuals, of the petitioner, stated by a respondent that something was going on here. And there are none. But you also have to think about, well, is there something else going on here that's a problem? And there are even allegations now of, for instance, someone carrying a firearm, displaying a firearm, which at a minimum, the court can take judicial notice, at a minimum would be at least felonious assault, potentially a 4-year felony, unlawful display of a firearm. I mean, these are serious allegations. These are criminal allegations. Police were not contacted. However, Department of Health and Human Services apparently was contacted. And there's nothing in the record to indicate to the court whether or not anything was followed up with that investigation or not. The court, on its own initiative, sua sponte, had called Chief Repke, Stephen Repke of the Sebring Police Department. I saw him in the courtroom. Actually, when the case was called, I saw him stand up, and which drew my attention to him as well. And so I'm trying to find out what indeed is going on here. That's what all the court's trying to do. Someone's parking in the wrong parking spot, or trivial matters like that. It may not be trivial to those who are at the apartment, but it's trivial, generally speaking, because we're talking about non-domestic stalking. We're talking repeated contact where there are threats involved. And what the court heard was basically what I find, based upon the testimony, simply a relationship that's gone bad and toxic to the point where, as soon as this court finds that if the respondent is even around the petitioner, and I can't help the fact they live in the same apartment complex, it brings up all these bad feelings and all these allegations are made. And I mean, it's just thick as thick can be here regarding what's going on or what's alleged to be going on here. To add fuel to the fire, I get a response from the respondent who's testified under oath that the petitioner, though she may be afraid that she's being stalked, posting messages on the respondent's apartment door. That's what she testified under oath. I allow final argument to allow the parties to raise their points, and then the court can make a decision based upon having all the knowledge here. Not once did I hear in the petitioner's prayer for relief and or final argument to say, that's not true, that didn't happen. So it's uncontroverted that petitioner is putting things on the respondent's door. And I know for the record, the petitioner shaking her head, but there's nothing in the record indicating that that was not done. So it begs the question, why in the world would someone need a personal protection order based upon alleged stalking when, one, the individual is not referenced in any Facebook messages, second, the respondent denies them that there were posts, but more importantly, the petitioner continues to go to the respondent and put items on the door. Why in the world Would you do that if you were afraid or you were stalked? There is absolutely no evidence in this case for a personal protection order. Personal protection order request is respectfully denied. That is all. Right.
Final ruling. Denied. Why? No solid proof of stalking, no direct threats, and actions that actually contradict the claim of fear. Balance scale. Lesson here. In court, evidence beats emotion every single time.